When someone comes into my office and says, I've been arrested with a felony, can we get the charges reduced? There's always a possibility in that. A couple of different ways it can get reduced, and one of the things I think is most important to understand is once you're arrested for a felony, it's important that you seek defense counsel right away, because there's a period of time from the time that you're arrested until the time that the state makes a filing decision that a defense attorney can help influence the prosecutor about what charges to file. For instance, let me give you an example. If someone's arrested for grand theft, that's any amount taken over $750, and let's say it was a close amount, or maybe that it had to do with merchandise that was taken but then returned back to the store, there could be an argument to be made that technically this is only a petty theft. So educating a prosecutor about the facts and circumstances of the case and not just giving it the police side of the story could help get that initial charge reduced from a grand theft to a petty theft. Likewise, a battery case could be you could be arrested for aggravated battery, but there could be an argument that it's just a simple battery. So having the right attorney, getting to a prosecutor before they file charges, is a way that you could get a case down-filed from a felony to a misdemeanor before the case has even gone to court. Likewise, even if you're charged with a felony and the prosecutor files as a felony, you may still have those same arguments later on down the line, but it's always better to start into court in misdemeanor court than it is to start in felony court. So the first way to go about doing it is contacting the prosecutor right away. Now, again, if charges are filed and you still have the same defenses, going through the discovery process, interviewing witnesses, actually examining the evidence is what they propose was the actual over the $750 threshold. You know, you could always make those arguments later on down the line. It could be subject to a motion to dismiss. It could be just a good argument to a prosecutor who then realizes, hey, we're not going to be able to prove this case, and then maybe makes a plea offer for a lesser charge or a misdemeanor charge. So those are the ways that you can get a charge reduced. Lastly, going to trial. Ultimately, the jury is the trier of facts, and for the same reasons, using the two examples, whether it's a battery case or a petty theft, or a grand theft versus a petty theft, the jury is the trier of fact, and they're the ones that are going to decide whether or not the state has proved beyond a reasonable doubt that in the theft case, the merchandise was over $750 or under $750, or in a battery case, whether it was aggravated or a felony battery or just a simple battery. So having a skilled attorney that can actually try a case is the last way to get those charges reduced. Now, if you've been arrested for a felony and you want your case reduced or possibly dismissed, give us a call.